Hello, and welcome to this, the second video of the series, Trust Made Simple. In our last video, we spent some time looking at some of the history behind trusts and some of the basic ideas which underline what a trust is, and a little bit of fun with the fairy story. But today we're going to go into something a little bit more concrete and look at what exactly a trust is. This is still on a very basic level. It's a little bit more complicated than that, but I think at the end of this session, you will understand a trust. You'll understand what a trust is. So let's start by talking about ownership. And as a society, as people generally, we think that ownership is great. We like owning things. It's an instinctive feeling. But it's helpful to think about actually why is ownership great? What is the good thing about ownership? And what I like to do is I like to analyze it and try and break it down into pieces. And in my opinion, the first thing that's good about ownership is that I have control. So if I own something, I am the boss. I decide. For example, if I own a house, I decide what color to paint the house. I am the boss, so if I want to, I can sell the house. I can rent the house. I can, if I want to, I could demolish the house or give the house away. It's my house, and subject to a few, let's say, limitations imposed by external forces such as the law, I can pretty much do whatever I want. And there's nobody else can tell me what to do. And that's great. So one of the good things about ownership is control. The second good thing about ownership is benefit. If I own something, then I can enjoy it. So in the case of a house, I can live in the house. I can sit in the garden, and I can, on a sunny day, sit under a tree and enjoy a beer. It's my garden, why not? I can rent the house and get money from the house. I can sell the house and get money in that way. And if I put all these things together, that's what ownership is. And that's great, most of the time. But there are some times, occasionally, when ownership is not so great. So let's look at some examples of reasons why maybe owning something wouldn't be perfect. First thing is that if you own something and it generates income, you have to pay tax on that. The second reason is that if you own something, people can sometimes see that you own the thing. In the case of our house, there's usually some kind of land register, and these things are quite often public. So nosy people could look at the land register and notice that you own this house. And you might not want that. If you own a lot of things, then other people can tend to sometimes be a little bit jealous about that. And that's not always ideal either. If you own something and you go bankrupt, then that's not convenient, because when you go bankrupt, your creditor or the bankruptcy official can potentially take your house away. So your house is vulnerable to attack. The same thing goes for lawsuits. If somebody sues you and you lose, then your ownership of the house could be under threat. If you get divorced, then the house can be threatened by the need to divide property between you and your future ex-wife or husband. And if you have a house, then it can attract unfortunate people. It can attract gold diggers to yourself and more often to your children. And all of these last four things together, I've grouped together with a blue square there, because these are things where there is a threat to your house or to your assets from an external source. And this is one of the ways that a trust is a very useful tool. We're going to go and talk a lot more detail about how that works in future videos. but this is one of the great things about trusts. The next thing that can sometimes be a problem is inheritance. In some countries there is testamentary freedom. It means that you can leave your estate, your assets to whoever you like. In other countries that is not so much the case, and there are some fixed rules about who it is that must inherit what from you. And even if there are not fixed rules, sometimes you want something a little bit more sophisticated than the standard will allow. One of my favorite examples is Warren Buffett. This is Warren Buffett, and he has a quotation, and actually I'm going to misquote him, I think, but he says something to the effect that he wants to leave his children enough money to do something, but not enough money to do nothing. And I think that's a very good concept, and it's a concept that I see shared by many of my own clients. They want to look after their children, they love their children, but they do not want their children to be spoiled or ruined by having access to too much money. And a trust is a great way of dealing with that problem. If you own a family business, then that can also be a problem when you pass away or when you retire. If you look at the statistics from the US, 75% of family businesses do not survive the transition from one generation to the next. The children get the business and they think that's great, I'm going to sell the business, or I'm going to try to run the business, or I'm going to make decisions that are not what the founder or the parents would have wanted if they had been alive. So again, taking that business out of the ownership of the founder can be very, very helpful. And last of all, in my opinion, there are some things that should not be owned at all. Sometimes things belong to ideas, or they belong to communities, or they belong to purposes. So, for example, a religious building, a church, shouldn't belong to somebody. It belongs to, perhaps it belongs to God, or it belongs to the community. Sometimes assets, for example, in the case of charities, should be dedicated to a purpose. Again, not belonging to any particular person. So that's an example also of when ownership can be not ideal. Okay, so it's good to own most of the time, but sometimes it's not so great. And when it's not so great, that is when a trust becomes a useful tool. Like I said, we will in future episodes go into much more detail of reasons why you might want to set up a trust, but that was just to give you a little taste. So here we are on the slide, and we start with our same picture we had 2 slides back. Here is somebody, and here is a house, and at the moment that person is the owner of the house. And in trust language, this person who is let's say the creator of the trust, he is sometimes, or she is sometimes called the grantor, or sometimes the founder, or sometimes the settlor. Different countries have different names for this person, but whatever the name is, this is the person who creates the trust in the first place, and it's usually the person who puts the assets into the trust. So, what happens? I'm going to call this person the founder, only because I'm used to using that terminology, but it could be settlor, grantor, whatever. The founder signs some documents, usually a whole pile of documents, and usually based on quite a long process of consultation with experts and advisors and lawyers and so on. And the founder creates this thing, which I have drawn as a cloud. Now, the reason I've drawn it as a cloud is because it's a little bit different from, for example, creating a company. Because when you create a company, you create almost like another person. A company has what's called legal personality. So a company can sign a contract, a company can be sued, a company can do many of the things that a physical person like you or I can do. It can't do everything, it can't die, but it has legal rights as if it was a person. A trust is a little bit different from that, because a trust is not a legal person, doesn't have legal personality. A trust cannot sign a contract. A trust actually, in a funny way, you could say a trust cannot really own anything, although it does. We'll talk about how that works. Instead, what you have with the trust is you have trustees. And trustees are the people who manage the trust and manage the trust according to the rules that they have been given. In this case, we have trustees who are called Fred and Susie. It's quite common to have more than one. It's a good idea to have two people or more than two people, partly because it's nice to share opinions and decisions, and partly because they can stop each other from doing crazy things. So they're both checking on each other. And it is Fred and Susie who manage the assets. And when I go to the land register and I look at who is the owner of the house, which I've put into the trust, or the assets in the trust, I don't see the trust, because the trust, remember, doesn't have legal personality. What I see Fred and Susie as the owners, but Fred and Susie as the owners as trustees of the XYZ trust in this case. So this is sometimes a bit confusing to people who are not familiar with trusts, because if you talk about Fred, for example, he is a person, he owns things, he owns his own house, he owns his own bank account. And if Fred were to go, for example, bankrupt or die, then his own house and his own bank account, of course, are part of his own assets, and they would be taken into account in the probate, inheritance, bankruptcy process. But Fred, together with Susie, is also the owner of the assets in this trust. But in this case, he's owning them with a different hat on. He's owning them in his capacity as trustee of the trust. And so this is owned by him, but not, let's say, personally owned by him. So if he goes bankrupt, or if he dies, or if something else happens, the assets of the trust are not his assets. They are the assets that are dedicated to the trust, and they are not under threat or attacked by these external forces. And the third group of people that we have are the beneficiaries. And these are the people who one day will be the owners of whatever is in the trust. They will benefit from whatever is in the trust. It's usually quite a lot more complicated than that. So we usually talk about the idea of discretionary trusts, which we'll come on to discuss later on. So it's not always the case that each one of those beneficiaries is the owner of a specific part of the trust, in the same way that they would be if they were shareholders of the company. More often it's the case that together, between all of them, they are somewhere the potential owners of the trust. And the next step is that we put the assets, in this case the house, into the trust. So now that house doesn't belong to our client or our friend, Mr. Founder. It's not his. If he dies, it's not part of his inheritance or probate process. If he goes bankrupt, that's fine, because it's not his asset anymore. If he gets divorced, for example, then again, it's not his asset. It belongs no longer to him. It belongs to the trustees in law, just as the castle in our last example belonged to Sigmund. but they are merely or only the holders of the house. They hold on to the house for the benefit of the beneficiaries. So that's great, because the house is in the cloud, and because it's in the cloud, it's very hard for anybody to attack. You might then say, well, yes, but now the founder has lost control over everything. And the answer to that question is, well, sometimes, yes, that's the best thing, but more often than not, that's not actually the case. So when the founder creates the trust, he or she also creates a whole set of rules about how the trust is going to be managed. Who will get the money? When will they get the money? What will be done with the money in the meantime? What are the rules for the trustees to follow? And those rules can be very general, or they can be very specific. So they can say, for example, if you're dealing with an aristocratic family and there is a castle, the rules may say, never sell the castle. Or they can be much more general. It's absolutely up to the founder to create whatever set of rules he or she wants to create, and the trustees, they have to follow those rules. So in this way, you can say that the founder has still kept control over the process. And in fact, there is one more thing the founder does to keep control, and that is what we call the power of appointment. So the founder has the power to decide who the trustees are. And unless there's some rule to the contrary, the founder also has the power to replace them. So if Fred and Susie do not do what the founder wants them to do, then the founder can simply say, okay, I'm very sorry, and goodbye, and replace them with somebody who will be more cooperative. So again, in this way, the founder is keeping control over the assets of the trust. However, it depends on what you're trying to achieve. It depends on which country you live in. But doing it that way may or may not be a terrific idea. Because if you keep too much control on paper, then sometimes the protections and the validity of the trust itself can be called into question. In other words, we'll talk about it in a future video. In other words, was it real? Did you really mean to do this? Did you really want to give up control? And if it looks like you didn't, then perhaps you haven't got a trust at all. Tied with that is this question of whether your trust is revocable. Revocable. If I make a trust revocable, then it means that I, as the founder, have the power to go and the whole thing is cancelled and I get the money back. Sounds great. Right? So I'm not really making any serious commitment, and if I change my mind, no worries. This is often, it's very attractive, but it's often not a good idea. And the reason why it's not a good idea is if you have the power to simply get the money back, then you actually have a bank account. That's what it really is. You have a place that you can go and simply withdraw money from. And if you were, for example, to go bankrupt or get divorced and you have a revocable trust, then the judge is going to say, well, this is just like a bank account. You can get the money out. And so I'm going to assume that you can do that and that you will do that. And I expect you to pay that money to your creditors or your future ex-husband or wife, as the case may be. Again, we'll talk about it in the future, but the structure of the trust is very important. It has to match up with the goals that you are trying to achieve. Another very common thing that you will see is one more person. And one more person, sometimes called a protector, sometimes called a supervisor, sometimes called an enforcer. And this is the person whose job it is to keep an eye on the trustees. So, while the founder is alive, the founder is normally the person who is keeping an eye on the activities and behavior of the trustees, and if they do not do what he wants them to do, then he can simply replace them with somebody who will do what they want to do. But again, that may not be a good idea, because again, it may not show that he really genuinely relinquished control over the house. And of course, after the founder has gone, then the question is, who is it that is controlling the trustees? Who is it that is checking on them? It can sometimes be the beneficiaries, but sometimes it can also be the supervisor, protector, or enforcer, who has then this power of appointment to make sure that the trustees are doing what they are supposed to do. So, that's a trust. It's actually not that complicated. You have a founder who creates a cloud which is managed by some trustees for the benefit of the beneficiaries. There is, of course, a lot more detail in real life, so you might get a trust document with 70 pages, but all it's really saying is this. Thanks a lot for watching. I hope you found that useful and helpful. If you'd like to see more of this, please like the video and please subscribe using the button that you can see just there. Thank you very much. Have a great day, and thanks again for watching.